The Code of Laws of the United States of America is the official compilation and codification of the general and permanent federal laws of the United States. It contains 51 titles, along with a further 4 proposed titles. The main edition is published every 6 years by the Office of the Law Revision Counsel of the House of Representatives, and cumulative supplements are published annually. The official version of those laws not codified in the United States Code can be found in United States Statutes at large. Level of law. In the United States, federal laws are subordinate to the United States Constitution but preempt state and local laws. Federal law that conflicts with the U.S. Constitution is invalid. State and local laws that conflict with either the U.S. Constitution or federal law are also invalid. Disputes regarding validity of a law and conflicts between federal and state laws are resolved by the courts. Both federal and state laws are considered valid, commonly referred to as constitutional, until challenged and declared otherwise. Even laws declared invalid remain on the statute books unless and until they are formally repealed, and some rulings of invalidity have subsequently been reversed. Also, in the case of conflict between federal and state laws, if the federal law is repealed, it would reactivate the force of the state law. Codification process. The official text of an act of Congress is that of the enrolled bill presented to the President for his signature or disapproval. Upon enactment of a law, the original bill is delivered to the Office of the Federal Register within the National Archives and Records Administration. After authorization from the OFR, copies are distributed as slip laws by the government printing office. The archivist assembles annual volumes of the enacted laws and publishes them as the United States Statutes at large. By law, the text of the statutes at large is legal evidence of the laws enacted by Congress. Slip laws are also competent evidence. The statutes at large, however, is not a convenient tool for legal research. It is arranged strictly in chronological order so that statutes addressing related topics may be scattered across many volumes. Statutes often repeal or amend earlier laws, and extensive cross-referencing is required to determine what laws are in force at any given time. The United States Code is the result of an effort to make finding relevant and effective statutes simpler by reorganizing them by subject matter, and eliminating expired and amended sections. The Code is maintained by the Office of the Law Revision Counsel of the U.S. House of Representatives. The LRC determines which statutes in the United States Statutes at large should be codified, and which existing statutes are affected by amendments or repeals, or have simply expired by their own terms. The LRC updates the Code accordingly. Because of this codification approach, a single named statute may or may not appear in a single place in the Code. Often, complex legislation bundles a series of provisions together as a means of addressing a social or governmental problem. Those provisions often fall in different logical areas of the Code. For example, an act providing relief for family farms might affect items in Title VII, Title 26, and Title 43. When the act is codified, its various provisions might well be placed in different parts of those various titles. Traces of this process are generally found in the notes accompanying the lead section associated with a popular name, and in cross-reference tables that identify code sections corresponding to particular acts of Congress. Usually, the individual sections of a statute are incorporated into the code exactly as enacted. However, sometimes editorial changes are made by the LRC. Though authorized by statute, these changes do not constitute positive law. Legal status. The authority for the material in the United States Code comes from its enactment through the legislative process and not from its presentation in the Code. For example, the United States Code omitted 12 U.S.C. AA millisecond 92 for decades, apparently because it was thought to have been repealed. In its 1993 ruling in U.S. National Bank of Oregon v. Independent Insurance Agents of America, the Supreme Court ruled that A Section 92 was still valid law. The LRC continues the process of revising, updating, and restating the existing body of statutory law in codified form. As the LRC completes particular areas of the law, It proposes that the Congress enact those titles of the Code as positive law. If a particular title of the United States Code is enacted into law, the enactment repeals all previous enactments on the subject, thereby making that title of the United States Code legal evidence of the law in force. However, in case of a conflict between the text of the statutes at large and the text of a provision of the United States Code that has not been enacted as positive law, the text of the statutes at large takes precedence. By law, those titles of the United States Code that have not been enacted into positive law are prima facie evidence of the law in effect. The United States Statutes at large remains the ultimate authority. If a dispute arises as to the accuracy or completeness of the codification of an unenacted title, the courts will turn to the language in the United States Statutes at large. Where a title has been enacted into positive law, however, a court may neither permit nor require proof of the underlying original statutes. The distinction between enacted and unenacted titles is largely academic because the code is nearly always accurate. The United States Code is routinely cited by the Supreme Court and other federal courts without mentioning this theoretical caveat. On a day-to-day basis, very few lawyers cross-reference the code to the statutes at large. Attempting to capitalize on the possibility that the text of the United States Code can differ from the United States Statutes at large, Bancroft Whitney for many years published a series of volumes known as United States Code Service, which used the actual text of the United States Statutes at large. Uncodified statutes, only general and permanent laws are codified. The code does not usually include provisions that apply only to a limited number of people or for a limited time, such as most appropriation acts or budget laws, which apply only for a single fiscal year. If these limited provisions are significant, however, they may be printed as notes underneath related sections of the code. The codification is based on the content of the laws, however, not the vehicle by which they are adopted. So, for instance, if an Appropriations Act contains substantive, permanent legislation, the permanent provisions will be incorporated into the code even though they were adopted as part of a non-permanent enactment. Organization: the code is divided into 51 titles, which deal with broad, logically organized areas of legislation. Titles may optionally be divided into subtitles, parts, subparts, chapters, and subchapters. All titles have sections, as their basic coherent units, and sections are numbered sequentially across the entire title without regard to the previously mentioned divisions of titles. Sections are often divided into subsections, paragraphs, subparagraphs, clauses, subclauses, items, and subitems. Congress, by convention, names a particular subdivision of a section according to its largest element. For example, subsection 3(b), if, is not a subsection but a clause, namely clause of subparagraph of paragraph of subsection. If the identity of the subsection and paragraph were clear from the context, one would refer to the clause as subparagraph, if. Not all titles use the same series of subdivisions above the section level, and they may arrange them in different order. For example, in Title 26, the order of subdivision runs, title, subtitle, chapter, subchapter, part, subpart, section, subsection, paragraph, subparagraph, clause, subclause. In Title 38 the order runs title, part, chapter, subchapter, section. Put another way, the title is always the largest division of the code, and the section the smallest, but intermediate levels vary in both number and sequence from title to title. The word title in this context is roughly akin to a printed volume, although many of the larger titles span multiple volumes. Similarly, no particular size or length is associated with other subdivisions. A section might run several pages in print, or just a sentence or two. Some subdivisions within particular titles acquire meaning of their own. For example, it is common for lawyers to refer to a Chapter 11 bankruptcy, or a subchapter S corporation. According to one legal style manual, a sample citation would be Privacy Act of 1974, 5 U.S.C. A millisecond 552 Read aloud is Title 5, United States Code, Section 552A, or simply 5 U.S.C. 552A. Treatment of repealed laws. When sections are repealed, their text is deleted and replaced by a note summarizing what used to be there. This is so that lawyers reading old cases can understand what the cases are talking about. As a result, some portions of the code consist entirely of empty chapters full of historical notes. For example, Title 8, Chapter 7 is labeled Exclusion of Chinese. This contains historical notes relating to the Chinese Exclusion Act, which is no longer in effect. Cases of awkward numbering. Sometimes, Congress or the LRC underestimates the future importance of a new government program, and does not reserve enough space in the U.S.C. section numbers for future statutes related to that program. Then Congress never gets around to the task of reorganizing and renumbering all the sections in a title, which forces congressional drafters to resort to awkward methods to shoehorn new laws into the existing section numbering of a title. One method is to add additional letters and numbers to section numbers. Another method is to simply jam more subsections under a single section number. In turn, some parts of the U.S.C. feature sections with strange numbers which have so many subsections included that they become very difficult to read. Many examples can be found in the statutes governing the huge Medicare and Medicaid programs, which were originally assigned, respectively, to Sections 1395 and 1396 of Title 42. Take for example 42 U.S.C. A.A. millisecond 1396 U2, D, 2, A, I, 2, which requires state approval of certain marketing materials. Versions and history. Early compilations. Early efforts at codifying the acts of Congress were undertaken by private publishers. These were useful shortcuts for research purposes, but had no official status. Congress undertook an official codification called the Revised Statutes of the United States approved June 22, 1874, for the laws in effect as of December 1, 1873. Congress reenacted a corrected version in 1878. The revised statutes were enacted as positive law, but subsequent enactments were not incorporated into the official code, so that over time researchers once again had to delve through many volumes of the statutes at large. According to the preface to the code, from 1897 to 1907 a commission was engaged in an effort to codify the great mass of accumulating legislation. The work of the commission involved an expenditure of over $300,000. But was never carried to completion. In the absence of an official code, private publishers once again collected the more recent statutes into unofficial codes. The first edition of the United States Code includes cross-reference tables between the U.S.C. and two of these unofficial codes, United States Compiled Statutes annotated by West Publishing Company and Federal Statutes annotated by Edward Thompson Company. Official code. During the 1920s, some members of Congress revived the codification project, resulting in the approval of the United States Code by Congress in 1926. The official version of the code is published by the LRC as a series of paper volumes. The first edition of the code was contained in a single bound volume. Today, it spans several large volumes. Normally, a new edition of the code is issued every 6 years, with annual cumulative supplements identifying the changes made by Congress since the last main edition was published. Digital and Internet versions. Both the LRC and the GPO offer electronic versions of the code to the public. The LRC electronic version used to be as much as 18 months behind current legislation, but as of 2014 it is one of the most current versions available online. The United States Code is available from the LRC at uscode.house.gov in both HTML and XML bulk formats. The United States legislative markup schema of the XML was designed to be consistent with the Acoma NTOSO Project XML schema, and the OASIS Legal Doc ML Technical Committee standard will be based upon Acoma NTOSO. A number of other online versions are freely available, such as Cornell's Legal Information Institute. Annotated codes. Practicing lawyers who can afford them almost always use an annotated version of the U.S. Code from a private company. The two leading annotated versions are the United States Code Annotated, abbreviated as U.S.C.A., and the United States Code Service, abbreviated as U.S.C.S. The U.S.C.A. is published by West, and U.S.C.S. is published by LexisNexis, which purchased the publication from the Lawyers Cooperative Publishing Company in 1997 as a result of an antitrust settlement. These annotated versions contain notes following each section of the law, which organize and summarize court decisions, law review articles, and other authorities that pertain to the code section, and may also include uncodified provisions that are part of the public laws. The publishers of these versions frequently issue supplements that contain newly enacted laws, which may not yet have appeared in an official published version of the code, as well as updated secondary materials such as new court decisions on the subject. When an attorney is viewing an annotated code on an online service, such as Westlaw or LexisNexis, all the citations in the annotations are hyperlinked to the referenced court opinions and other documents. Other relevant codifications: the code generally contains only those acts of Congress known as public laws. The code does not contain statutes known as private laws. It also does not contain statutes that are not considered permanent. Nor does it contain regulations adopted by executive agencies through the rulemaking process set out in the Administrative Procedure Act. These regulations are published chronologically in the Federal Register and are then compiled by topic or subject matter in the Code of Federal Regulations, which constitutes an additional important source of federal law. Number and growth of criminal laws. There are conflicting opinions on the number of federal crimes, but many have argued that there has been explosive growth and it has become overwhelming. In 1982, the U.S. Justice Department could not come up with a number, but estimated 3,000 crimes in the United States Code. In 1998, the American Bar Association said that it was likely much higher than 3,000, but didn't give a specific estimate. In 2008, the Heritage Foundation published a report that put the number at a minimum of 4,450. When staff for a task force of the U.S. House Judiciary Committee asked the Congressional Research Service to update its 2008 calculation of criminal offenses in the U.S.C. In 2013, the CRS responded that they lacked the manpower and resources to accomplish the task. Parts of interest: the Uniform Code of Military Justice is contained in Title 10, Chapter 47. It defines infractions such as absence without leave and contains the popularly known phrase, "conduct unbecoming an officer and a gentleman." Title 11 is the U.S. Bankruptcy Code. Some of the different types of bankruptcy are commonly referred to simply by their chapter numbers: Chapter 7, Chapter 11, Chapter 13. Title 18 deals with federal crimes, penalties and prisons. Title 26 is also known as the Internal Revenue Code. Much of Title 26 is administered and enforced by the Internal Revenue Service and is one of the largest portions of the code. Title 28 governs procedure in the United States federal courts. Title 42 is a large and complex title which includes statutes governing several large federal government programs like Social Security and Medicare, as well as entitlements, civil rights and many social programs. One provision, 42 U.S.C. A.A. Millisecond 1983, is the basis for a wide range of federal civil rights actions in federal courts. It is the codification of the Civil Rights Act of 1871. Section 1983 cases include suits alleging use of excessive force by police and First Amendment suits against public schools to maintain church-state separation. Section 1983 itself is quite short. The annotations, however, span several volumes. Chapter 6A of Title 42 is the Public Health Service Act. Titles that have been enacted into positive law are indicated by blue shading below. Titles whose laws have been repealed are indicated by red shading below. Note: the U.S.C. has produced a draft version of the codification of Title 35. Includes appendix of provisions not yet enacted into positive law. Proposed titles: the Office of Law Revision Counsel has produced draft text for an additional 3 titles of federal law. The subject matter of these titles exists today in one or several titles. If and when enacted, These titles would actually perform two functions: moving law from one location in the U.S. Code to another, and to convert it into positive law. The U.S.C. announced an editorial reclassification of the federal laws governing voting and elections that went into effect on September 1, 2014. This reclassification involved moving various laws previously classified in Titles 2 and 42 into a new Title 52. See also, List of U.S. state legal codes, United States reports, notes. External links: United States Code from the Government Printing Office, United States Code from the Office of Law Revision Counsel, United States Code from Cornell's Legal Information Institute, United States Code from tax26.com, United States Code from Open Jurist, Popular Names of Acts in the United States Code from Cornell's Legal Information Institute, Positive Law Codification in the United States Code from the Office of the Law Revision Counsel, United States Statutes and the United States Code, Historical outlines, notes, lists, tables, and sources from the Law Librarians Society of Washington, D.C., How to Count Citations in U.S. Law Using XML Files from Congress from Gary Sealing, Unraveling the Mysteries of the U.S. Code from the Law Librarians Society of Washington, D.C.